Welcome to the Deep Dive. Today we're diving deep into the world of South African criminal law. We've got your criminal law textbook and study guide, and it looks like you want to get a handle on the basics, the specific things about the South African system, and maybe some of those interesting cases, the ones that make you go, huh, that's weird.
Yeah, like a legal detective kit. We'll give you the tools to break down a crime, from its history to the little details about intent.
Perfect. So study unit 1, that's like the foundation, right? Historical stuff, where the laws come from, all the things that make South African criminal law what it is today.
Exactly. It's all about the foundation. So South African criminal law, it doesn't come from just one place. It's got Roman Dutch law, English law, even some customary law. It's a pretty interesting mix.
Okay, interesting mix. And where does apartheid fit into all of this? It seems like more than just history, like it's part of the legal system itself.
You're absolutely right. The legacy of apartheid, it still shapes South African law today. We'll see this tension as we go through the material, how the law tries to match up with the post-apartheid constitution, always changing to fix the injustices of the past.
It's like trying to blend two totally different worlds.
Yeah.
Okay, so study unit 2. What are the key takeaways?
Study Unit 2, it goes into the main ideas that run criminal law in South Africa, understanding what makes something a crime and all the different ideas about punishment. It's like the core of criminal law, the building blocks.
So it's not just memorizing laws, it's about why they exist.
Exactly.
Yeah.
This study unit asks big questions like, what's the point of punishment? Is it about payback? Is it about stopping crime from happening again? About helping criminals change their lives? Or is it all of those things together? We also look at this thing called the legality principle. Basically, the idea that laws need to be clear and easy to understand. Vague laws. They cause problems, make things uncertain, and they can even be challenged in court just because they're unclear.
That makes sense. You don't want to be punished for something you didn't even know was a crime. The study guide mentions something called theories of punishment. Can you talk about that a bit more?
Sure. It's interesting, actually, how different societies have thought about punishment over time. There are 4 main theories we're going to look at: retribution, deterrence, prevention, and rehabilitation. Retribution, that's about punishment as a form of, revenge, an eye for an eye kind of thing. Deterrence, that's about stopping crime in the future, either for the individual who did it or for society as a whole. Then there's prevention, which is about keeping criminals away from the public, incapacitating them, essentially. And finally, there's rehabilitation. Rehabilitation is about helping criminals change and rejoin society.
Wow, that's a lot to think about. How do these theories actually play out in South African law, like in real-life cases?
It's a balancing act. South African courts, they look at all these theories when they decide on a sentence. They try to find a punishment that fits the crime, but also considers the criminal situation and, of course, what's best for society as a whole.
So there's no one set way to punish?
Nope, not at all. Each case is different, and the court has to weigh a lot of different things. Like, think about it. A first-time offender who did something non-violent would be treated differently than someone who keeps committing crimes and is a danger to everyone, right?
Yeah, that makes sense. It sounds like being a judge is a tough job.
Yeah.
Okay, let's move on to study unit 3. This one seems to get into the specifics of what actually makes something a crime, right?
You got it. Study Unit 3, it breaks down the elements of a crime. It's like learning the blueprint for what makes someone criminally liable.
Okay, break it down for me. What's this blueprint you're talking about?
Think of it like a 3-legged stool. Definitional elements, unlawfulness, and culpability. First, you need the act itself to fit the legal definition of a crime. Those are your definitional elements.
So, like, if the law says theft is taking someone's property without their consent, the act has to have all those pieces: taking property, no consent.
Exactly. You nailed it. But it's not enough to just match the definition. The act also has to be unlawful, meaning there's no good reason for it under the law, like self-defense. That could make something that looks like a crime actually legal.
So if someone attacks you and you fight back, even if you hurt them, it might not be a crime because you were protecting yourself.
Right. You got it. And finally, we have culpability. This is where things get really interesting because we start looking into the mind of the accused.
The guilty mind. That whole mens rea thing you hear about, right?
Bingo! Culpability, it's about whether the person had the right mental state when they did the act. Did they mean to do it? Were they reckless? Or were they just careless?
So this study unit is building on those first two, right?
Yeah.
The theories of punishment start to make more sense when you're talking about specific crimes.
Absolutely. Criminal law is like a big puzzle. All the pieces connect. In Study Unit 4, that goes even deeper into the puzzle by exploring defenses.
Defenses. So even if someone does something that's technically a crime, they might have a way to argue that they shouldn't be punished.
Exactly. Defenses are arguments that try to knock out one of those three legs of criminal liability we talked about. They might say the act itself wasn't a crime, that it was justified, or that the person didn't have the mental state needed for it to be a crime.
Okay, let's talk specifics. The study guide mentions necessity and private defense. Those seem pretty complicated.
They are. Necessity, it's about those really extreme situations where you have to break the law to avoid something even worse. Imagine you're stuck in a burning building and you have to break a window to escape.
Yeah, that makes sense. You're causing property damage, but you're doing it to save your own life.
Exactly. But the law has to be careful, right? Was the danger you were trying to avoid really bigger than the harm you caused? Did you have any other options? There's this case, the Van Wyck case, where a shopkeeper killed an intruder to protect his store. That case really shows how tricky these ethical questions can get.
Wow, killing someone to protect property. That brings up some really tough questions about how far necessity goes.
It does. And then there's private defense, the right to protect yourself or someone else from an attack. This defense, it's all about proportionality. The force you use to defend yourself has to match the threat you're facing.
So if someone pushes you, you can't just pull out a gun and shoot them.
Right.
Right, there has to be a balance.
Exactly. We'll be looking at cases that show how this works in real life. Situations where it's not always clear if private defense applies. Things get a bit blurry sometimes.
This is making me think about criminal law in a whole new way. It's not just about right and wrong. It's about these complicated situations where you have to figure out what's fair.
You got it. And those gray areas, that's where things get really interesting. Let's move on to Study Unit 5 now. This one goes deep into mental states, the idea of criminal capacity.
Okay, criminal capacity. Is that like being able to commit a crime?
It's more about whether you're mentally able to understand what you're doing and what the consequences are. South African law has this two-part test: cognitive and conative functions. Cognitive is about knowing right from wrong. Conative is about being able to act based on that knowledge.
So even if you know something is wrong, if you can't stop yourself from doing it, that could affect your criminal capacity.
Exactly. And this brings up some big questions about mental illness and how it affects whether someone is responsible for their crimes. The study guide also mentions something called non-pathological criminal incapacity.
Non-pathological, so not caused by mental illness.
Right. Think about times when someone's under extreme stress or they've been provoked and they temporarily lose control of their actions. South African courts have dealt with this defense, especially after this controversial case, the Chrétien case. We'll go over that in detail later.
This deep dive is really showing just how much goes into figuring out who's responsible for a crime. It's not just about what they did, it's about the context, their mental state, even their emotional state.
It's a complex puzzle, that's for sure. And each piece is important for seeing the whole picture. Let's move on to Study Unit 6, which focuses on specific types of dolus, or intention.
Okay, intention. That's a big one. How does South African law differentiate between different types of intent?
Good question. The study guide breaks down dolus into three main forms: dolus directus, dolus indirectus, and dolus eventualis. Dolus directus is the most straightforward one. It's when your main goal is to achieve the prohibited result. Think of a hitman who's paid to kill someone.
Okay, so their intent is pretty clear. They want that person dead. What about dolus indirectus?
Dolus indirectus is when you know the bad result is almost certain to happen, even if it's not your main goal. The study guide uses the example of someone setting fire to their business to get insurance money. They know destroying the building will almost certainly hurt or kill anyone inside, even if that's not their main goal.
It's like a side effect they're okay with.
Yeah.
And what about dolus eventualis? This one seems tricky.
Dolus eventualis, that's the toughest one to wrap your head around. It's when you foresee the possibility of the bad outcome, but you do it anyway, accepting that risk. It's a controversial area in South African law, lots of cases trying to define and apply it.
Sounds like it comes down to the difference between accepting a risk and actually wanting a specific outcome.
Exactly. And that's why dolus eventualis has caused so much debate in the courts. We'll be looking at specific cases to see how this type of intention works in real life.
This is making me rethink everything I thought I knew about criminal law. It's not just about good guys and bad guys. It's about these complex mental states and trying to figure out if someone is really to blame in these nuanced situations.
Exactly. That's what makes it so interesting and challenging intellectually. Let's move on to study unit 7 now, which goes into the idea of negligence.
Okay, negligence. This is about carelessness, right?
Right.
Like not paying attention and accidentally causing harm.
You're on the right track. Negligence is a different type of culpability. It's about failing to see and avoid a risk that a reasonable person would have seen and avoided.
So it's not about wanting to cause harm. It's about not living up to a certain standard of care.
That's it. South African law uses the reasonable person standard to decide if something was negligent. It's an objective test, meaning we ask, would a reasonable person in the same situation have seen the risk and tried to avoid it?
So if I'm driving and not paying attention, and I run a red light and cause an accident, even if I didn't want to hurt anyone, I could still be in trouble for negligence.
Exactly. Because a reasonable driver would have been paying attention and wouldn't have run the light. But there's also a subjective element to negligence. We also have to consider whether that specific person could actually see and avoid the risk.
So like if someone has a vision problem that makes it hard to see traffic lights, that could be a factor.
Right. The court would have to ask, would a reasonable person with the same vision problem have been able to avoid the accident? This study unit also looks at this debate about whether personal things like age, experience, and cultural background should be considered when deciding if someone was negligent.
Sounds like there's a lot of discussion about where to draw the line between what's objectively reasonable and what's fair to consider about the individual situation.
There is, and that's what makes criminal law so dynamic and interesting. It's a constant process of refining legal ideas to deal with how complex human behavior can be.
This deep dive is really going above and beyond. It's not just about memorizing legal terms. It's about understanding the big ideas and grappling with the tricky questions that make criminal law so fascinating.
We're just getting started. We've only just begun to explore this intricate world of South African criminal law. There's still so much to uncover, from specific crimes to the interplay between legal principles and real-life cases.
I'm ready for it. Let's dive into the next study unit and see what other legal puzzles we can unravel.
Welcome back to our deep dive into South African criminal law. It's amazing how much we've already covered, from the historical roots to those mind-bending concepts like dolus eventualis.
Yeah, it's been a wild ride so far. So where are we headed next in our exploration?
Well, next up is Study Unit 8, and this one delves into some fascinating gray areas. Participation in crime and incomplete crimes. You know, those situations where things aren't so black and white.
Okay, participation in crime. Does that mean like accomplices and accessories? You know, the people who help the main criminal but might not actually do the crime themselves?
You got it. This study unit explores all the ways people can be held responsible for a crime, even if they didn't personally do all the parts of it. We'll be looking at concepts like common purpose, joinder in common purpose, and even withdrawal from common purpose.
Common purpose, that rings a bell. Is it like when a group of people work together to commit a crime, even if they all have different roles to play?
Exactly. Think of a bank robbery. You've got the mastermind who plans the whole thing, the getaway driver waiting outside, and then the people who actually go into the bank and take the money. They all have different jobs, but they're all united by this common purpose: robbing the bank.
So even if the getaway driver never steps foot inside the bank, they can still be held responsible for the robbery.
That's right. This idea of common purpose lets the court say that the actions of one person in the group count for everyone else, as long as they shared the same intention and were working towards that goal. It's about holding everyone accountable for their part in the plan.
But what if someone agrees to be part of a crime but then changes their mind and backs out?
Yeah.
Can they still be in trouble under this common purpose thing?
That's where withdrawal from common purpose comes in. South African law says you can use this as a defense, but there are some pretty strict rules.
So it's not enough to just say, Newt, I'm out.
Not at all. The study guide explains that you have to completely separate yourself from the group's plan and take real steps to stop the crime from happening. It's got to be a genuine and effective withdrawal, not just a last-minute change of heart.
So the court will really look at the timing and everything the person did to decide if they truly withdrew from the plan.
Okay, what about incomplete crimes? Is this about those times when someone tries to commit a crime but they don't quite succeed? Like attempts and conspiracies?
Exactly. We're going into the world of inchoate offenses now. Study Unit 8 looks at attempts, conspiracy, and incitement. These are all about punishing people for taking steps towards a crime, even if they never actually commit it.
So even if you don't reach your goal, you can still be punished for trying.
Right. And this brings up some interesting questions like, how far do you have to go before it's not just thinking about a crime, but actually attempting it? South African law has developed tests to figure out where that line is. Yeah, I bet it gets pretty tricky trying to pinpoint that exact moment when someone goes from thinking about a crime to actually trying to do it. What about this idea of impossibility? What happens if you try to commit a crime that's just, well, impossible to do? Can you still be charged with an attempt?
It might sound strange, but yes. We'll look at the Davies case, which dealt with this very issue. It focused on the person's intention, even if their method was totally unrealistic.
Impossible crimes. That sounds like something out of a movie.
It does, doesn't it? But think about it. Someone tries to kill another person using a voodoo doll. They really believe they're causing harm, but of course it's impossible. South African law still sees this as an attempt because it focuses on what the person intended to do.
So even a misguided or impossible attempt can land you in hot water. What about conspiracy? How is that different from an attempt?
Conspiracy is about the agreement to commit a crime, even if no one actually takes any steps towards doing it. It's about punishing the planning stage the moment that criminal agreement is made.
So if a group gets together, let's say they plan to rob a bank, but then they get scared and give up before doing anything, they could still be convicted of conspiracy just for making that plan.
That's right. The agreement itself is seen as a dangerous thing that needs to be punished. And then we have incitement, which is about encouraging or persuading someone else to commit a crime.
So if I say to someone, hey, you should totally rob that bank, they've got tons of money, I could be charged with incitement even if they don't actually rob the bank.
Exactly. It's all about your intention to influence someone else to commit a crime, whether or not they actually do it. This whole study unit is about catching criminal activity early on, stopping those dangerous intentions before they turn into action.
It's like preventative criminal law. Okay, let's shift gears to Study Unit 9, which focuses on specific types of crimes. This is where we get into the real-world stuff, right?
You got it. We're going to dive into different categories of crimes, starting with crimes against the state. These are the big ones. Treason, sedition, and terrorism offenses that threaten the government and society as a whole.
Treason? That sounds serious. Is that like betraying your country?
Exactly. Treason involves actions that endanger the safety or stability of the state. Things like waging war against your own country or helping its enemies. Sedition is a bit broader. It's about inciting rebellion or violence against the government. And terrorism, well, I'm sure you're familiar with that. It's about using violence or threats to achieve political goals.
So crimes against the state are all about protecting the government and keeping society stable.
Precisely. And then we have crimes against the administration of justice, which are all about making sure the legal system works fairly and honestly.
So this is where things like perjury come in, right? Lying under oath in court.
Exactly. This category also includes things like obstructing justice, which covers a bunch of actions that interfere with investigations, trials, or carrying out sentences.
So tampering with evidence, threatening witnesses, helping a fugitive escape, those would all fall under obstructing justice.
Exactly, you're getting it. And then there's contempt of court, which is about protecting the authority and dignity of the court itself. This includes things like being disruptive in court, disobeying court orders, or publishing stuff that could prejudice a trial.
It's like creating a safe space around the court so that justice can be done fairly without any interference.
Exactly. Now let's move on to crimes against the person, which are those offenses that target an individual's physical and emotional well-being.
Okay, so this is where we see the classic crimes, right? Things like murder, assault, and rape.
You got it. We'll be breaking down each of these crimes, looking at the different levels of severity and specific variations. For example, within assault, there's common assault, assault with intent to do grievous bodily harm, and even sexual assault, which has its own complex set of legal principles.
And this is where those ideas of intent and culpability we talked about earlier become really important, right?
Absolutely. Figuring out the right charge often depends on some pretty fine distinctions, like how much intent there was, how much force was used, and what kind of injuries were caused. We'll be looking at real cases to see how the courts weigh these factors.
I'm starting to see how everything connects. The general principles, the elements of a crime, the defenses, and now the specific types of crimes. It's all coming together.
It's like we're building a legal toolbox. Now let's talk about crimes against property offenses that target a person's belongings.
So this is where we see crimes like theft, robbery, and fraud, right? crimes that hit us where it hurts our wallets.
Exactly. We'll unpack each crime, looking at the different ways they can be committed and what sets them apart from each other. For example, what's the key difference between theft and robbery?
Is it violence? Like if someone pickpockets your wallet, that's theft. But if they hold you at gunpoint and demand your wallet, that's robbery.
You nailed it. And then there's fraud, which involves deception and trickery to gain a financial advantage. The study guide covers various forms of fraud, from forgery to embezzlement.
It's amazing how creative criminals can get, always coming up with new ways to take what doesn't belong to them. What's next?
Well, now we move on to a category that's pretty unique to South African law: statutory offenses.
Statutory offenses. What are those?
These are offenses created by specific laws, often to address certain social concerns or fill in gaps in the common law. For instance, South Africa has a very detailed law dealing with sexual offenses.
So it's like lawmakers stepping in to create new crimes that reflect changing societal norms and concerns.
Exactly. This study unit shows how dynamic criminal law is, always adapting to new challenges and protecting vulnerable people.
This deep dive is really eye-opening. Criminal law isn't just about punishing bad guys. It's about protecting important values, keeping society stable, and making sure justice is served.
It's a powerful tool for shaping society and ensuring justice for all.
It's been a really insightful journey so far. I feel like I have a much better grasp of how complex and important this field is.
And we're not done yet. There's one more study unit to explore, focusing on those crimes that don't neatly fit into the other categories. Think of it as the miscellaneous section of criminal law.
Okay, bring on the miscellaneous. I'm ready for anything at this point. What kind of offenses are we talking about?
Well, get ready for some intriguing ones. We'll be looking at crimes related to religion, crimes against public order, and even environmental crimes.
Crimes against religion. Now that's interesting. Is that about things like blasphemy?
It can be. This category covers offenses that target religious beliefs or practices, like sacrilege, desecrating religious objects, and even disrupting religious gatherings.
So it's about protecting religious freedom and making sure people can practice their faith without being harassed or interrupted.
Exactly. And then we have crimes against public order, which are all about maintaining peace and stability in society.
So things like rioting, public violence, inciting unrest.
Precisely. These offenses target actions that threaten the peaceful coexistence of individuals and disrupt the social fabric. And finally, we have environmental crimes, which reflect the growing global concern for protecting our planet.
So we're talking about things like illegal dumping, poaching, and polluting.
Exactly. These crimes show how the scope of criminal law is expanding, moving beyond traditional offenses to address new threats to our collective well-being.
This deep dive is really highlighting the breadth and depth of criminal law. It's not just about punishing individuals. It's about protecting fundamental values, maintaining social order, and safeguarding our planet.
It's a complex and ever-evolving system, that's for sure. And we'll continue our exploration in the next part of our deep dive.
Welcome back for the final part of our deep dive. It's amazing how much we've uncovered about South African criminal law already.
We've gone from the historical roots to those super complex concepts, like dolus eventualis. It's been a pretty thorough journey.
It has. And now we're at Study Unit 10, which feels like the miscellaneous section, all those unique offenses that don't fit neatly anywhere else.
That's a good way to put it. It's like a collection of fascinating crimes, a real testament to how adaptable South African law is.
Okay, I'm intrigued. What kind of offenses are we talking about?
Get ready for a mixed bag. We've got sexual offenses, assault, and even that interesting one we touched on earlier, failure to give a satisfactory account of possession of goods. Remember that.
Yeah, I remember. Let's start with sexual offenses. The study guide mentions a specific section in South African law dealing with consensual sexual penetration of children. This is obviously sensitive, but it's important to understand how the law handles these tricky situations.
Absolutely, it's important. South African law recognizes that children, because of their age and maturity, well, they might not truly understand what it means to consent to sexual acts. Section 15 of Criminal Law, Sexual Offenses and Related Matters, Amendment Act, that's the one that deals with this. It makes sexual penetration with a child a crime, even if the child seems to consent.
So even if a child willingly participates, the adult can still be charged.
That's right. The law draws a very clear line to protect children no matter what. For this specific section, a child is defined as 12 years or older, but younger than 16.
So any sexual activity between an adult and someone under 16 is a crime.
Generally speaking, yes. However, there's this small exception called the close-in-age defense. It applies when the age difference is less than 2 years.
So like if a 15-year-old has sex with a 17-year-old, it might not be prosecuted.
Possibly, but it's not a guaranteed defense. Prosecutors consider everything, maturity levels, whether there was any pressure or abuse of power.
It sounds like a delicate balancing act, protecting children, but also acknowledging that teenagers, especially those close in age, sometimes engage in consensual sexual activity.
Exactly. It shows how South African law tries to address these complex social issues, finding that balance between protection and personal freedom. Okay, shall we move on to assault? The study guide goes deeper into this crime, breaking it down into different elements and types.
Yeah, let's do that.
The study guide explains that assault is when you unlawfully and intentionally use force on another person, or when you make them believe you're about to use force. It can be done in two ways, either by actually using force or by making someone reasonably believe you're about to hurt them.
Okay, so actually hitting someone is assault, that's pretty obvious. But what about threats or gestures that make someone scared for their safety? Does that count?
Absolutely. Those actions can be assault too, as long as they create a genuine fear in the victim that harm is coming right away, like pointing a gun at someone even if it's not loaded, or making threats that sound like you're going to use violence.
So it's more about how the victim feels, not necessarily what the perpetrator planned to do.
Right. The law understands that the mental harm from a threat can be just as real as physical harm. The study guide also makes a distinction between common assault and assault with intent to do grievous bodily harm.
Can you explain the difference?
Sure. Common assault usually involves minor injuries, maybe even no injuries at all. It's more about scaring or intimidating the victim, not really trying to seriously hurt them. Assault with intent to do grievous bodily harm, though, that's a whole other level. It means the attacker specifically wanted to cause serious injury.
So a slap could become an assault, but a stabbing would be assault with intent to do grievous bodily harm.
Exactly. That's a
Hmm.
good way to think about it. The severity of the injuries and what the attacker intended, those are the big factors in deciding the right charge.
This deep dive is helping me see all the subtle differences between different crimes.
That's what it's all about, really, understanding the nuances of human behavior and how much harm different actions can cause. Speaking of nuances, let's get to that failure to give a satisfactory account of possession of goods crime, which is pretty unique to South Africa. It seems like it hinges a lot on circumstantial evidence.
You're right. It's all about the circumstances. Section 36 of the General Law Amendment Act, that's the one that created this offense. It's for those situations where someone has something that's probably stolen, but they can't explain how they got it. So if the police find me with a stolen TV and I don't have a good story, I'm in trouble.
You could be, yeah. Having stolen goods without a reasonable explanation, well, it often suggests you were involved in the theft, or at least knew they were stolen.
But what if I really did buy it on the street, totally unaware it was stolen?
That's where things get a bit tricky. The test for this crime isn't about what you actually knew, it's about what a reasonable person would have thought. It doesn't matter if you genuinely believed you were buying it legally, a reasonable person in your shoes has to have believed it too.
So even if I made a genuine mistake, I could still get convicted.
That's the part that's controversial. Critics say it punishes people who didn't do anything wrong, and it puts the burden of proof on the accused instead of the prosecution. They think the prosecution should have to prove the person knew or should have known the goods were stolen.
It sounds like the law is trying to discourage people from buying stolen goods, even if they weren't part of the actual theft.
Exactly. And that brings us back to that constant tension in criminal law. Balancing public safety with individual rights. It's never easy.
Wow, we've covered so much. From the very basics of South African criminal law to the details of these really unique offenses, it's been an incredible journey.
And a journey that never truly ends, right? Criminal law is always changing, reflecting our values as a society and responding to new challenges.
This deep dive has given me a whole new appreciation for this field. It's complex, important, and I'm definitely inspired to learn more.
And that's what it's all about, sparking curiosity and giving you the knowledge to explore further.
Thanks for joining us on this fascinating adventure through the world of South African criminal law. Until next time, keep those minds curious and keep diving deep.